problems. And the primary point for me in the camera in the courtroom issue has been that regular appearances on TV would mean significant changes in the way my colleagues could conduct their lives. My anonymity is already gone, so it's already affected the way that I can conduct my own life. But for some of my colleagues, they have not yet lost that anonymity. So I think that the security issues are at the foremost of all of our minds now since 9/11. I think they would certainly be become even more significant with more exposure. But I think our people have been up to the task, and I think this committee, when we've had personnel-related issues involving security, you've been very, very responsive. When we've had structural issues around the court, you've been very, very responsive. This body has been very responsive after the attack on the family of one federal district judge, and has really enhanced security, personal security for all judges around the country. So I think we have to continue to be vigilant, as each of us has to be vigilant. But as of now, I think our people have done an outstanding job in cooperation with this body.
I could just register a slight disagreement with my colleague on the point about personal security as it affects the decision to have cameras in the courtroom. I would be ready, for debating purposes, to concede that if it's in the public interest to have cameras and it makes my life more difficult, that's just the price I have to pay. But I don't think it's in the best interest of our institution. You talked initially about separation of powers. We use separation of powers and checks and balances as if they're interchangeable terms. They really have different thrusts, different directions. I said this recently in the other chamber. Separation of powers means that each branch has a certain degree of independence so that it can perform its duties the right way. Checks and balances means there has to be some interrelation between the two, and we come and ask you for the money here. The president nominates and the Senate confirms and so forth. Those are the branches working together. I think that separation of powers, if not in a formal sense, acting as even if it does not act in a formal sense, so that you cannot exercise your power with reference to cameras in the courtroom, in an informal sense, what I've called the etiquette, the deference that one branch shows to the other dictates that you should allow us to make this decision. Our dynamic works. The discussions that the justices have with the attorneys during oral argument is a splendid dynamic. If you introduce cameras, it is human nature for me to suspect from time to time that one of my colleagues is saying something for a soundbite. Please don't introduce that insidious dynamic into what is now a collegial court. Our court works. We teach by having no cameras that we are different. We are judged by what we write. We are judged over a much longer term. We're not judged by what we say. Now, if you want to have an Oxford debate, and I drew the affirmative for cameras in the courtroom, I could make a lot of points about educating the public, about educating our attorneys. Some attorneys would profit greatly from watching oral arguments in order to make their own better. So there are good reasons for it. But all in all, I think it would destroy a dynamic that is now really quite a splendid one, and I don't think we should take that chance.
Totally agree.
Yeah, well, good. Welcome. You're across the street. We don't see each other often. It's good to have you here.
Thank you, sir.